I understand that this is a difficult and challenging case for both sides, and certainly the facts are not easy for the court to address. Let me state up front that the court has reviewed everything. I've closely considered the testimony that was presented today and all of the evidentiary submissions that were provided to the court in advance to review in preparation for this hearing, and I've taken all of that into consideration as to what will ultimately be my ruling here. I will say up front that the court's job is not to please either side in terms of its ruling on sentencing, and I don't ever consider that. I always approach it from the standpoint of, based on the totality of circumstances in any given case, what is the appropriate sentence to mete out an appropriate justice in the case that I'm dealing with at that specific point in time. So I suspect that whatever I do today will probably make everyone unhappy, because it's going to be a decision that nobody gets what they want, and sometimes that's probably the best approach by the court. Let me talk a little bit about the facts that I am basing my decision on, and what I've observed during the course of this sentencing hearing, and in the context of the evidence that I'm privy to by virtue of having sat on at the trial. I found that, at least based on the evidence, that the defendant clearly, and he was found by the jury to have been guilty of the 3 charges of which they rendered the verdict on. And so that puts me in a position of finding that the defendant engaged in conduct that the jury found to be criminal for an extended period, and that the conduct he engaged in was considered, it was calculating, it was methodical, and it was planned. I mean, you look at the construction of the room and what that took to put into place, and just the structure, not only of the building of the room itself, but of the method of discipline during the time that RF spent in the state of Florida. The one thing that, and the reason I mention that is because there were plenty of opportunities. This wasn't a one-day deal or a 2-day deal. This was a situation that occurred over a 6-week period in the state of Florida. And so what that tells me is that there were plenty of opportunities that the defendant had to reflect on whether what he was doing was wrong. And over the 6-week period in the state of Florida, it appears that he never took the time to reflect, and he never concluded that what he was doing was wrong. And there is evidence to suggest that he did know what he was doing was wrong, because there was evidence that he instructed RF to dump the urine bucket in the bushes and not let the neighbors see him. There was evidence of Mrs. Ferriter removing the bucket from the room prior to law enforcement going into the room. So there was evidence that the court can at least look to that convinces me that the defendant knew what he was doing was wrong, and never reflected once to take a remedial or corrective course. And I think ultimately that's what influenced the jury's decision in this matter. So there were opportunities along the way for the defendant to do what I would call a sanity check on whether what he was doing was the correct approach, and maybe a need to reverse course. That never happened. I mention this because I spent a lot of, this isn't the first thought or consideration that I'm giving to this. I've spent a lot of time dealing with this case and trying to determine whether the defendant has any redeemable qualities that should influence the court's decision. And on this point, I cannot say that the defendant is devoid of any redeemable qualities. I've obviously reviewed a lot of statements. I've reviewed photos, and it certainly appears that at times his family had very good times and experiences, and that at times he was attempting to be the basically textbook father. But that's what was on the surface. Because what's clear is that although things appeared to be very, very perfect on the surface, that what was going on below the surface was not so perfect, and that a very deep, dark family secret was being maintained in that household, and that is the defendant clearly was abusing his oldest son, which the jury has found that he did. And I will tell you that it's not lost on the court that the defendant was struggling himself as to how to deal with the discipline of the child. I don't think that the evidence that was submitted, it all reflected RF as a problem child to the extent that he was really beyond anything that normal kids do. And sitting up here on criminal court, I see it every day. And things like stealing candy, wrestling with your sister and injuring or something like that, those are not serious instances that would ever justify the level of discipline that was imposed here. And the other thing I would say is even, and let me just digress for a moment. I've looked at the redemptive qualities that the defendant has, and he doesn't have a prior history. He has no criminal background, and he has experienced a loss himself in terms of the utter collapse of his family and having all of his children taken away. But I also note that he stated that he was born and raised on Quantico, at Quantico Base. So I suspect that tells me, knowing that it's a Marine Corps base, that he probably grew up in a very disciplined environment. And I don't know if anybody's ever seen the movie The Great Santini, but there was a movie where Marine, the Great Santini, he was a tough disciplinarian father as well. And if you ask Pat Conroy today, he probably would find a way to say he loves his father in some ways, but I'm sure at some point in time he hated his father. And the reason I point that out is, again, I'm looking for any redemptive aspect of the defendant's nature and character that would give me some ability to factor that in as a positive point in this case for sentencing. At the end of the day, the jury found the defendant guilty of the 3 charges that were in the verdict, and so I'm bound by that. So the first question that I will have to look at is whether there's a legal basis for a downward reduction. And before I get into that in more detail, I will say that whatever the sentence is that I impose in this matter, it will be for a defined period, and it will come to an end. And at some point, the defendant will have the opportunity to try to put his life back together. And I get it that his life has been turned upside down, and from his vantage point, probably destroyed at this point. But the pain and the suffering that he's experiencing will end at some point, and he'll have an opportunity to move forward. The concern I have is that for the victim, the treatment to which he was subjected to by his father will be with him for a lifetime. And I know that, and I always listen to the victim's statements very carefully, and I know that he's professed that he loves his father, and he's asked for the court to take a specific route in terms of sentencing. But the bottom line is that he was subjected to an abuse that should never be experienced by any kid, from any parent. And I can't just look at the victim's wishes alone in determining what is an appropriate sentence, because no parent can ever be justified in doing what Mr. Ferriter did to his son, RF, in this particular instance. And I remain concerned that, as I've said, that most, if not all, of the problems were caused by the defendant himself and his discipline of the child. And the long-term harm and emotional impact that the victim probably doesn't even know he is going to suffer for the future as a result of the conduct he was exposed to. So, as you can tell, I've considered a lot of things. So this brings me to the ultimate question of what is an appropriate sentence for the defendant on the charges for which he has been found guilty. So let me address the matter of the defense motion for downward departure. All right, so as I've said, the first 2 points that were raised by the defendant for downward departure, I don't believe that they met their burden of establishing a sufficient factual basis based on competent, substantial evidence for the utilization of Section 921.00262F, which grants the court the ability to downward depart where the victim was an initiator, willing participant, aggressor, or provoker of the incident. I don't believe that under the circumstances of this case that there is any basis for the court to use this as a legal prong justifying a downward departure. And I think if there was, then it would potentially throw child abuse cases, flip them on their head in terms of what parents can do and ultimately what the court can do in terms of sentencing. Likewise, I don't find any merit in the ground that was asserted in 921.00262F dealing with the question of the need for restitution outweighing the need for a prison sentence. Under the circumstances involving RF in this instance, I don't believe restitution is a factor at all. It won't be a factor in my sentencing decision. So again, I don't think the defense has met its burden here. So that brings me to the last prong that I did give very serious consideration to and quite frankly troubles the court the most in terms of where my legal ruling comes out on this, and that is the portion of section 921.0026 that states that the court may consider the enumerated downward departure grounds, but I'm not limited to them. So that means that if there's competent substantial evidence of something else, that I can consider it. And as I understand the Montana's case, and I get that the Montana's case cited by the defense is not on all fours, a perfect match, but the court does make a statement there that does give this court some feeling that I could look to this particular section as a reason to downward depart if I wanted to. And that is, while no case has ever permitted a downward departure sentence based on that reason, and that was the reason they were talking about in Montana's, such a reason was not otherwise prohibited by law. So that brings me to the question that I ask, is the issue of, without in any way, shape, or form looking to the conduct of the victim as justification or excuse here, can I look to the mental status or situation that the defendant was experiencing and use that as a possible basis under the catch-all provision that would give me the ability to downward depart? And I'm not aware of any case that says I can't. And so, not being aware of any case that says I can't, I'm going to make a finding that under 921.0026, under the catch-all provision, that if I think the competent substantial evidence does support the argument that I can look to the conduct of the defendant and what he was experiencing and what he believed to be the case, and whether that belief was irrational or not influenced what turned out to be horrible decisions, can I consider that? Because I think that is analogous to what the court did do in the Montana's case. And so I'm going to find that under that section I can, and I do find there's been enough evidence for me to at least consider the catch-all provision. And let me talk about a few things that I recall hearing today and also that I recall hearing during the trial. There's no question that the defendant was acting aggressively and irrationally at times during the videos that we saw, and there is no question that there was a methodical, calculated effort to discipline his son in a way that I think he thought was appropriate and believed was appropriate. Although, again, that's weakened by the fact that he did try to conceal that conduct from the neighbors, and so that cuts against that conclusion somewhat. But I do think that the defendant probably came from a disciplined environment, having grown up in Quantico, and maybe that's all he knew. I don't know that that's the case or not, but having been a Marine, I know how Marines operate, and I know how disciplined the environment can be. And I will say that as horrible as the conduct was, the defendant's response in dealing with his son in terms of the room, if you look at the photos, there clearly were times that this family was a better functioning family. They had good times. It wasn't all horrible. It wasn't all the most deplorable of circumstances. And I get it. Now that the two daughters, that they seem to be extremely harmed by this. But there were times when they appeared to be enjoying things, and I've seen those photos. So I don't cast the broad net of putting the defendant in the category of always having been a terrible father. There were times when he tried to do the right thing, and I think did do the right thing in terms of exposing his kids to things that were positive in their lives. But that's not the end of the story, because he obviously exposed them to things that were deplorable, criminal, and that no children, neither the victim nor their siblings, should have ever been exposed to. And any type of physical abuse where a child is being held by the throat by a parent is just not acceptable in any civilized society, and certainly putting a child in a locked room, restricting the access to any air conditioning is not appropriate, certainly not in Florida. So at the end of the day, I'm going to find a basis to downward depart under the catch-all. So the question then is whether I should exercise my discretion in doing it. Because I do find that this is a somewhat unique and complex situation because of the situation that maybe the victim has RAD. It's not totally clear that he does. It's not totally clear that what he has wasn't caused specifically by how he was treated by his parents. But I do recognize that there's enough that it creates an issue where this is not your normal situation of child abuse where their children are put in a cage or a box, and there's nothing that explains what was going on here. Ultimately, the state is requesting 15 years, and I think the defense is requesting 1 year based on the motion, followed by probation. And I do note that I can go all the way up to 40 years. So at the end of the day, as I said before, I am totally convinced that what I do will not please anyone here, but ultimately the buck stops with me, and the responsibility ends with me and falls on my shoulders to issue a sentence that I think is appropriate to the circumstances. And I will say that it is not lost on the court that not only is the defendant here going to be the one to suffer the weight of the sentence that I impose, but the entire family has already suffered the trauma and the ramifications and consequences of the defendant's conduct. And on that issue, I do think that the defendant exercised and expressed his remorse at that. I just wish he'd have been a little more forceful in getting the point to me that he actually acknowledges that what he did was wrong, and I didn't get that. I still didn't get that, because I have some sneaking feeling that if all things being equal, the defendant might say that he would do the same thing over again because he thought it was the right thing to do out of love at the time he did it, and that creates problems for me. I hope that I'm wrong on that, but at least that doubt has been allowed to remain in my head. So, all right, so enough said on this. I am going to exercise my discretion to downward depart here. I'm going to, but I will tell you that the downward departure is not even remotely close to what the victim has requested, nor the defense counsel requested. And at the end of the day, the sentence that I'm going to impose is going to be longer than what the guidelines provide. I'm going to downward depart from 75 months to 60 months, and followed by 5 years of probation, 2 years of the first 2 years of probation of which will be in CC2. During the term of probation, the defendant is not to have any contact initiated with any of the 3 older children. Those children will be free once they reach age of majority to have contact with the defendant if they so choose. In any event, even if the children so choose to have contact with the defendant, they will not be able to do so until the defendant has first completed the following conditions of probation. I'm going to require that the defendant undergo a 40-hour anger management class, which can be taken while he is in custody. that he undergo a 40-hour parenting course, and that he also undergo a mental health evaluation. With respect to the youngest child, given the nature of the appointment or the adoption there, I'm going to require any contact or visitation be supervised, but ultimately subject to any restrictions that the dependency court imposes, because obviously the dependency court, if they're still involved, then maybe they're not involved anymore. They don't have any jurisdiction anymore. So I'm going to leave it that there be no contact unless it's supervised with respect to the younger child. And the reason the court is allowing that is the circumstances that presently exist. The youngest child has been adopted by the wife's mother. And it's just not realistic in the court's view that where the adoption was permitted of the wife's mother, that any rational people looking at this situation would conclude that the parents are not going to have any contact with that child, or they should not have allowed the adoption to be by the wife's mother to begin with. So
There's some confidential provisions that we're not privy to, but that's generally the expectation, is that there'll be substantially like that there won't be.
I am privy to them because I was present, and I don't believe that's true, but I think that if the court could say that whatever is in, I just don't know if the easiest thing.
well, what does the why don't you approach on that one point, because I don't want to inadvertently disclose something that's privileged. All right, so with respect to contact with the minor, the youngest child, I'm going to allow supervised contact as permitted by the adoptive mother, but it must be supervised. So there shall be no unsupervised contact between the youngest child and the defendant where there isn't another adult present. And I'm also going to, it's just as a condition of that, require that the defendant not be in any way, shape, or form engaged in the discipline of the youngest child. That is something now that rests solely with the adoptive mother, and the defendant has no say in that. I want to make sure that that's clear. Let me comment just very briefly, and then I'll be concluding this hearing. Ultimately, when I started this process, I was looking at a sentence that was in excess of what I've ultimately rendered today. So the court was moved to some extent by the tremendous showing of support that the defendant had and the number of character references, who I'm sure all saw the side of the defendant that is the side that we've heard, the two sides of the same coin. But there was enough support for Mr. Ferriter to, at least for me to have some comfort in concluding that at his core, although he did a very, very, very bad thing here, was not an innately evil person. And so that's why I've ultimately elected to have the sentence be what I've indicated. And as harsh as that may seem to some of the members of the family and friends of Mr. Ferriter. I will tell you, take some solace in that it's a lot less than what I originally started out when I looked at this for purposes of consideration of a sentence. The other thing I will tell you is, although in every case is unique and dependent on the facts and circumstances, it's not unusual for a victim to come into the court and express their love for a parent who has abused them or to ask for a lighter sentence. We see that all the time, and some would say that that is a reflection of a psychological harm or phenomenon of how abused kids react to things. But that doesn't mean I ignore it, and I certainly, it was too heavy a lift to go with what the victim was requesting here, because there has to be some punitive aspect that doesn't, from a societal standpoint, encourage parents to do what was done here and think that they're going to be dealt with lightly. I don't think that the court has dealt with Mr. Ferriter at all lightly. I think I've dealt with the court or dealt with Mr. Ferriter appropriately. And so I just want to be clear for those who think it's too much, it's less than what I started with, and for those that thinks it's not enough, that's why I wear the robe and I make the decision. So ultimately, that's my responsibility. So that's the court sentence in this matter. Madam Clerk, what is the court cost?
Yeah, I just need to,
If you need to clarify something, we can do that.
yeah, I just need to put something on the record, and I'm sorry, I have to do a little bit.
Yeah, go ahead while she's looking up the court.
For the record, the state objects
To the downward departure?
to the downward departure, to think that there is not there's not competent substantial evidence of the basis for downward departure, and also that it's not a permissible under 92.126 to depart on the basis of the mental status of the defendant, or that the defendant held an irrational belief during the course of the act. And so based on that, we think that there is not a legal basis for the departure.
All right, fully expected. The court always knows when I'm getting into an area where you never know how an appellate court is going to react, so I fully expected the state to object to the downward departure. Anything else you need to state, Ms. Murad, for the record?
Not for the record. I do have a request that the court recommend that when Mr. Ferriter is eligible, that he be at Sisseco Palm.
That's pretty standard. Just prepare the order that provides for that, and I certainly, usually the state doesn't take a position on that, right? All right, so the court will grant that.
Thank you. And then my other request is we will be filing a motion for appellate bond. It'll be filed tomorrow. Could the court order that he remain in county custody until the hearing of that bond motion, which I'm hoping will be near Thanksgiving?
It's not going to be Thanksgiving because I need to hear that, and I won't be around next week. So I will order that the defendant remain in custody here in Palm Beach County and not be transported until after I hear the motion, and I'll set that as quickly as I can.
Are we able to set a date today, or is that?
No, I'm going to need to see the motion and see how much time is going to be involved with it.
Understood, Your Honor. I'll prepare an order to the effect of both.
All right, Madam Clerk, court calls, please. All right, so you tell me, Ms. Murad, reduced to a judgment, or do you want to have a payment plan, or what?
Can we do 10 years to pay so that he can do it during the course of his probation?
That'll be fine. A condition of probation. 10 years
That's fine.
is a condition of probation. All right.